Hello, everyone. Good evening, but good morning, also good afternoon for those who will see and watch this episode later. We are here in another column of Canal Arbitragem, Arbitech. We're going to talk about technology in Colombia. So I invited some amazing guests to share their experience with you. It's our first talk here in the Arbitration channel in English. So yeah, I expect to have more international guests in the next months. And I believe that working and getting to know better the scope and how technology is developing, and of course regulation, and how lawyers are working with technology in Latin America is very interesting. And this is a window that will be open here in the arbitration channel in the next months and next episodes. So telling in order to enjoy this episode, I would like to pass the word to our prestigious guests. So Athenea, can you please come and talk about a little bit so people can get to know you better?
Okay, thank you, Daniel. Thank you for the invitation. Hi, everyone. My name is Athenea Saavedra. I'm a Colombian lawyer and also a lawyer admitted to practice in the US, in the state of New York. Currently, I work in matters related to health, but especially in health tech matters. And also, I apply a methodology which is called legal design. That's what I do on my day to day, and I'm very happy to be here. I pass the word to Erick.
Thank you. Thank you, Daniel. Thank you, Athenea. It's my pleasure. I am a Colombian lawyer. I am working in a fintech area, and it's my pleasure to be here.
Okay, nice to have you, Erick. Nicolás?
Thanks so much, Danny. Such a pleasure, such an honor to be with you, with an old friend. We met, I think, in 2019 in Williamsburg in the US.
Yeah,
So
exactly.
I cherish those moments, and I have this wonderful friend from Brazil, which also actually motivated me to move to Brazil to be briefly in 2022. So, hello everyone. My name is Nicolás Lozada. I'm a passionate guy about digital justice, and I've been working on online dispute resolution for the last 12 years, including heading a company called Redek, which is basically online dispute resolution with a K, just to make it more interesting. And also, I'm a professor at several universities in Colombia, including External University.
Perfect. So, getting started, I'll stick with you, Nick. So I would like to know what is the framework of digital justice in Colombia? What are the problems related to access to justice? Because I believe that they probably motivated you to develop your studies and your company in ODR services. So I'd like to hear about that, because that is a very interesting topic for us Brazilians, since we have like a serious crisis in justice. So I would love to hear you more, because
all right,
I'm used to hear you, but
allow me to put it more visual. So I have a very brief presentation that I'm going to start with. So let's start with the whole screen. So all right, so this is legal technology trends in Colombia focused on digital justice. And then the example I always like to bring forward is the situation of my aunt. My aunt's name is Maritza Lozada, and she's a 65-year-old woman. And her husband passed away in 2017. And even though we lived through the pandemic, we lived through law on digital justice in Colombia, law 2213 of 2022, she has not received a solution yet. So the the lawsuit was filed in 2018, and it's been 6 years, and we haven't had a single hearing yet. So it's a horrible lack of justice. It's a horrible representation of what should justice be. And then, so the story is this: my uncle, he passed away in 2017. Then she requested survivor's pension to the authority called Pensiones. 2018, the lawsuit started, and it's 2024, and the first hearing has not yet taken place. So, what digital justice, we always tend to relate, the use of technology in the service of justice. I think it goes way beyond. And I want to present to you what brought me together with my good friend Danny, ODR, online dispute resolution, which basically means when you have a platform, a mechanism dedicated for justice, for dispute resolution, and how it applies to ADR, alternative dispute resolution, say mediation, conciliation, arbitration, negotiation, but also how it applies to the justice sector in general. How can judges use platforms, artificial intelligence, for the purposes of delivering prompt and fair justice? And then this trend started to become more cohesive starting 2020, when ODR, people started to talk about it. I was talking about it since 2012, but I was a voice in the desert. I think pandemic was a tragedy in many ways, but it was also a huge opportunity for us, because since 2020, there's a 25% annual growth. And this annual growth has really opened our eyes for the need to have dedicated systems, the need to adopt to a digital environment in many aspects, but particularly in the justice area. But this is not new. It comes from e-commerce. So in terms of e-commerce, this trend started back in 2012. In 2012, there was a bigger influence from private companies, some of which had started back in the 90s, but say Amazon, eBay. But since the 2010s, many other companies started to adopt platforms for the purposes of solving e-commerce disputes. For example, when it comes to Airbnb, which is a huge ODR platform, well, it became popular in 2010. And then that also applies to Uber, to Rappi in Colombia, to many companies that we are very familiar with. And then the whole logic of ODR is that when it comes to electronic transactions, uh, the whole life of the transaction can end up in a dispute. So you need to cover both cycles: the cycle of the electronic transaction, e-commerce, but also the cycle of the electronic dispute. And then you can have the whole life of the dispute, but you can solve it through technology, through what we call modules. So the module related to the e-commerce transaction, purchase or sale, and the module related to claims, to disputes arising from this purchase. And then what's going on? So say starting 2017, 2015, is more financial ODR. So not only e-commerce platforms, we started to see more banks using this. So say Citibank in the US started to adopt ODR platforms for resolving disputes. I just recently received a resolution on a claim which I filed online through electronic means a few months ago in January. But banks are also catching up to this trend. And even though it's in the legislation in Colombia, at least since 2012, with the adoption of the arbitration law, of the law 1563 of 2012, virtual arbitration is now becoming a trend, but that's starting in 2020s. And actually, that was due to the pandemic. So the arbitration centers were forced to, and then allow me to be reiterative, they were forced to enforce the law in the use of electronic means. For instance, the Bogotá Chamber of Commerce, the Cali Chamber of Commerce, or the Medellin Chamber of Commerce started to adopt more um, eh, tangible means for dispute resolution, and now are in the conversations to really have ODR platforms for their dispute resolution. Um, Now, when it comes to financial ODR, complaints and claims have also become more sophisticated. And now there's a tendency. So if at some point for an e-commerce transaction, the Consumer Protection Authority, the Superintendency of Industry and Commerce, started to have their own system, we now start to see financial institutions such as the Monetary Authority of Singapore, and in this case, the Superintendency of Finance of Colombia. So the legal trend, the trend for legal tech here is to have not only ODR for companies, for banks, but also for financial institutions and financial authorities. Um, And then when it comes for virtual arbitration, getting back also to the use of ADR, we have to distinguish between electronic ADR using electronic means, for instance, for notifications, for hearings using Zoom, or the use of email or WhatsApp for communications between arbitral tribunals and parties. For instance, 70% of the hearings in 2022 in the Bogotá Chamber of Commerce were virtual. You're starting to see at least the need to get to a wider use of technologies through ODR platforms. In the same manner, SIG Facilita is transforming itself, and it's trying to become more and more updated to the needs of the consumers, because SIG Facilita, which is the ODR by the Consumer Protection Authority in Colombia, the SIC, uh, was very good. It was a mediation ODR that was implemented in 2016. It's not enough, because when it comes to ODR, you always have to keep innovating. And SIG Facilita was stuck in technologies of 2016. So the need, one of the legal tech trends for ODR is the adoption of updated ODR platforms, in this case, for the Superintendency of Industry and Commerce. And how can I not mention Redek, the solutions network that I work with and that I've been promoting for the last 3 years. What we're doing in Redek is try to implement customized solutions to companies, public institutions, and also international institutions. We're now working with the Monetary Authority of Singapore, with the Emirates Development Bank, with the Bank of England. So we're trying to have both a domestic reach, but also an international reach, wider grasp of what we want to do. And what we're trying to do with Redek is to have a regular, like established platform, what we call Redek Vanilla, the basic form of Redek, which is scalonated. So it follows three tiers, three stages, starting with direct negotiation, followed by mediation, and followed by arbitration. This follows the general standards as stated by ICODER, the NCTDR, and uh, for instance, with Danny, we met at an NCTDR meeting back in 2019. So it follows the general rules, but we want to make it more sophisticated. We want to go from a regular platform to something that can actually make use of artificial intelligence. And in Redek, we're implementing AI not as the basis. I think it's AI is just a tool, but not an ODR platform as such. It's a tool. So we are trying to, or we are at the moment, implementing artificial intelligence tools that can complement or accessorize the Redek platform. So our platform is becoming more and more sophisticated. It's using more and more artificial intelligence, and it's aimed to solving disputes even at the judicial system level. And that's why we're now working in conversations with the Superior Council of the Judiciary and also with other jurisdictions such as Panama, Paraguay, and others around the world. So I will be very happy to continue with this conversation. This was just a very brief introduction to what we want to do. I look forward to speaking to you, Danny, and to talking to my very good friends, Athenea and Erick.
Thank you, Nico. Thank you for your very intelligent remarks on ODR. Yeah, I remember when you met. It seems like a century ago. Yeah, but we still have work to do, especially and yeah, and congratulations on Redek and what you have developing. The last time we catch up, I think 2022, that we had time to talk about it. Yeah, I see that you develop it a lot and it's still on the road. Yeah, I think we have pretty much the same problem here as SIC Facilita with our Consumer Protection Authority ODR method. It's still like it's good, but it's still it's outdated. It has to be developed, and there's the need to improve and use of more up to date technology. So talking about since we're talking about these similar problems that we have in Colombia and this challenge that we have in Colombia and Brazil, Anthony, I would like to hear from you since you are working with healthtech for some time now. I've heard that probably it was voted, I think, on August or maybe on September, the data protection law in Colombia, or I believe that it's being discussed by the Congress, but it's a very similar law from the GDPR and the Brazilian data protection law, the LGPD. So I believe that we have pretty much the same challenges when we are dealing with health tech. So I would like to hear from you your views on that, and especially now that we are discussing AI, which will imply the need of new governance strategies and will, of course, bring new challenges to the processing of data, which is in the end of the day one of the main assets of a health tech. I'd like to hear your opinion on that.
Well, thank you for that question, Daniel. I think it's a very complex one, but nonetheless, here in Colombia, we do have a regulation, but it has not been updated yet. There was a bill, but it didn't pass. So now we're currently discussing a new one. So the current framework that we are discussing actually has some part related to the GDPR, but on the other hand, has other things which are more inclusive and more related to local matters. However, specifically regarding health, I would say that there are some definitions in this draft which I think do not solve completely all matters related to health tech. I mean, on the one hand, there's no specific regulation on health tech here in Colombia. Health tech is something quite novel here. I know that in Brazil, you have much more development on this. Actually, as long as I understand, half of all startups on health tech are from Brazil, at least in Latin America and the Caribbean. But in Colombia, it's still lower the investment. I think you have around like 350 or so startups there, while we only have like 120 or so on. So you can get an idea. And also specifically about the regulation, then when we read that draft that now is being discussed, they try to create definitions specifically for biometric data, health data, neuro data, and so on. But in the end, all of this is health data, which is sensitive data. So it does not really solve all the matters that can come across when you implement technology within health, right? And I would say that in my opinion, actually, it can make confusing the application of a potential regulation like that one, since in the end, if we start subclassifying all types of health data, it's going to be very difficult to interpret that law when you have a real case, right? So to me, what they should try to do is, for instance, try to analyze what would be the impact of the protection of data protection rights like sensitive data in light of these new technologies. But also, you know that we cannot speak in general about all these technologies since they also have different categories. You cannot speak in general about AI systems. Yeah, it depends on what type of AI are we talking about. And that also is extended, it's applicable to health, right? So I'd say that one of the main challenges is that the framework is still non-existent for something as specific as health tech. But on the other hand, I would say that in practice, we can see that all these startups and all these companies that are trying to innovate in health, some of them, I mean, I've seen several scenarios. So one of them is, for instance, the ones that just want to innovate because of the sake of innovating, right? So they are not really interested even in knowing if there is any type of governance framework that is applicable or not, or even if there is any type of potential risk. Some even mix the concept of artificial intelligence with automation. So in the end, everybody now is talking about artificial intelligence, but not everything is really artificial intelligence, right? On the other hand, I've seen, for instance, some companies of these ones that say, no, we comply in matters related to privacy with GDPR and HIPAA, so we are done. That's it. We are completely full with all these standards, so we have no privacy issues.
I have
But
a privacy policy. That's it.
exactly. But when you start
Yeah.
looking into details and you try to understand what does it mean for them to comply with GDPR or HIPAA, you start noticing when you make a diagnosis or something similar that they have a lot of things that are not being covered. Right? And especially when you're speaking about health, since it's something so sensitive, which may create biases and discrimination and so on, then it's something that brings up all type of alarms. Yes, and I have also identified, for instance, some of them that say, no, we only develop the algorithm and we offer it as a service, as a software, so we have no privacy issues at all. And I said, okay, maybe they don't know what happened in the past with the big companies like Microsoft and Google, that under GDPR, at least, they were considered as processors of all this data. So I start looking at all these startups, and I think that we as lawyers have a big field here to help them and to orientate them, and of course, with the main purpose of protecting the health and the privacy of all patients. We are all patients, or at least we're gonna be at some point in our lives. So we in our law firm, I have a law firm which is called Almaster. We provide all these type of consultancy for companies that have these innovations, and also we help them designing the best way to gather all this information and to protect in appropriate way this information, by using a methodology which is called legal design. So this comes from design thinking, and it has a very brief steps that you have to follow in order to create a good prototype, in this case, a good system or model, or it depends on what type of technology you want to develop. But I think it's very useful to start since the beginning. Also, I have found, for instance, companies that say, no, we have encryption and therefore everything is anonymized and there are no issues with privacy, so we are done. And when you start asking, you can identify that at some point there might be a risk of re-identification of all this data, which is something that we have to keep in mind, because currently there are several lectures where you can identify that this is a concern that is rising every day more and more. And also, I would say that cybersecurity is the other big issue of this, along with privacy. I've seen a good practice, for instance, in cybersecurity in some clients. They say that they try to have hackers to try to test their systems constantly, and to prevent potential hallucinations or biases and things like that. But when it's about health, is it enough? I mean, what's the type of diligence that is expected whenever we're dealing with health data? I think there are still so many questions that have not been answered, especially because, as we know, the law cannot follow the rhythm of the technology. So probably we will have at least to wait what's going to be the interpretation in other countries. I'm sure that Europe might be one of the first one where interpretations will come. We can see that some of the authorities, at least in privacy, they have been providing interpretations related at least to how can be understood, for instance, the principle of legitimate interest, because that's like the most open interpretation that they have there in Europe. But we will see how it comes. But more concerning to me is how we in Latin America are going to apply all of this, because we cannot just copy something that is happening in Europe. Our reality is completely different. And our systems as well. For instance, here in Colombia, we have a law that intends since like 5 years ago now, in February, 5 years ago, it was issued, and it intends to create their interoperability in the medical records. But it has not been applied yet. I think in Brazil, you have something a little bit more advanced regarding medical records.
In
But
the
here,
public sector is a little bit better, yes.
exactly. But here, we still don't have even the pilot. And it's supposed to be fully implemented by February 2025. So if we cannot even implement that, I don't know what's going to happen with other technologies. But this is something definitely very passionate, and we are very happy to work on this and to help all these innovators and startups to try to do it well. Yes, and not to feel that, oh, because there's no specific law that applies to health tech, then nothing applies. No, that's not like that. There are governance frameworks that we have to follow because there are other laws that are applicable.
Yeah, no, that's very interesting, because the traditional Silicon Valley model of move fast and break things doesn't work when you are dealing with health. When it's a very sensitive matter. So yeah, we have to take a. I think that from one point of view, especially in Colombia, because in Brazil we adopted, as you are aware, the data protection law, which is almost a copycat from the GDPR. I disagreed with that at the time. I wrote some articles regarding that, but yeah, the law is enacted and is enforced and is being applied. I don't think it was the best option. I think Colombia is going through an interesting path, adapting to the region, to the region aspects and difference. Of course, we are dealing with totally different societies when you're dealing with Latin America and when you're dealing with Europe. But I believe that there is an opportunity, maybe in the lack of a specific regulation, to try to work with the public authorities, the regulators, to try to build sandboxes, to innovate, and as you probably are aware, with legal design, and try to draw like a regulation which is appropriate to the needs of the society vis-a-vis the promotion of technology and innovation. I think that may be a good way. In Brazil, we did it a lot with the financial system, and maybe one of our national champion was founded by a Colombian, which is Nubank. For those who don't know, Nubank is right now we have almost half of the Brazilian population, which is more than 200 million people, have a Nubank account. So it's huge. I think the number of the clients are 115 million in Latin America, Brazil, Colombia, and Peru. So yeah, and they are growing like in a very fast paced. And of course, regulation and sandboxes and gave the opportunity for the flourishment of the fintech sector in Brazil. And of course, as in health tech, you can't move fast and break things when you're dealing with financial regulation, because otherwise you may end up committing a crime against the financial system. So it's a very regulated sector. And I would love to hear you, Erick, since one of your main scopes of work is fintech, how this sector is developing in Colombia and the challenges that you face before regulation. I think it would be really nice for everyone to hear your views on that.
Thank you, Daniel. It's my pleasure. And the evolution of fintech regulation in Colombia reflects the country efforts to stay at the forefront of financial innovation while addressing the needs of a growing digital economy. Uh, and in the early stage, Colombia's financial regulatory framework was focused on traditional banking institutions, leaving little room for innovation. However, Colombia faced increasing pressure to modernize its regulatory structure to accommodate new technologies and business models. One of the first steps towards a more inclusive regulatory framework was the enactment of Law 1735, which introducing the concept of sociedades especializadas en depósitos y pagos electrónicos, SEDPE. SEDPE is a special financial institution here in Colombia, and these entities were specifically designed to allow non-banking institutions to offer payment services, providing a legal framework for digital wallets, payment processors, and mobile banking services. This law represented a significant milestone in financial inclusion here in Colombia, and it enabled a more diverse range of companies to offer services traditionally dominated by banks. Uh, Following this law, Colombia introduced here the decree 222 of 2020, further expanding the regulatory scope to facilitate or to more facilitation about low value deposits and simplify the regulatory requirements for fintech companies. This move was critical for the growth of payment services, mobile wallets, and digital lending platforms. By reducing entry barriers, the decree opened the door for new players, allowing startups to offer innovative financial solutions without the heavy regulatory burdens. The government commitment to fostering innovation is also evident in the regulatory sandbox initiative, which was established here in Colombia by the Superintendencia Financiera. And this sandbox allows fintech startups to test their products and services in a controlled environment, offering a safe space for experimentation while maintaining regulatory oversight. The goal is to strike a balance between innovation and consumer protection, ensuring that new financial services are both effective and safe. The fintech companies in Colombia face several ongoing challenges in keeping up with regulatory change. One of the most significant challenges is regulatory complexity. Many of the regulations governing the financial sector were designed with traditional institutions in mind, and adapting them to the fast world of fintech can be difficult. For example, compliance with anti-money laundering and the know your customer KYC requirements is essential, but it often requires a substantial investment in technology and personnel to ensure that these processes are both efficient and secure. Um, Another major challenge is the fragmentation of regulatory oversight. Fintech companies in Colombia must navigate a maze of different regulatory bodies, each with its of requirements. Uh, Here in Colombia, in addition to regulatory fragmentation, fintech companies must also contend with taxation issues. The tax system in Colombia is not fully adapted to digital business models. Um, for example, companies that operate across multiple jurisdictions may face questions about where they are required to pay taxes, especially if either services are or offered online. Consumer protection is another area where fintech companies face increasing pressure. Uh, as more Colombians turn to digital financial services, there is a growing need to ensure that consumers are protected from fraud, data breaches, and other situations. Financial, as a result, fintech companies must not only comply with consumer protection, uh, with the consumer protection regulations, but also invest in educating their customers about how to use their products safely and effectively. Finally, the biggest challenge facing both regulators and fintech companies is the need to balance innovation with financial stability. While regulators want to encourage the growth of the fintech sector, they must also ensure that the financial system remains stable and that consumers are protected. Um, this requires a flexible regulatory approach that can adapt to rapid pace of technological change. In conclusion, Colombia's fintech regulatory landscape has come a long way, but there is still work to be done. However, fintech companies must continue to navigate a complex and evolving regulatory environment, balancing the need for innovation with the demands of compliance. As the sector grows, ongoing collaboration between regulators and industry players will be essential to ensure that Colombia remains a leader in fintech innovation while maintaining the integrity and stability of its financial system.
No, thank you, Eric. Yeah, it was really a class on financial regulation, at least in a financial regulation Colombia 101. I learned a lot, even though it was like short. Of course, we are here It's hard to deep in certain teams. We don't have time, but yeah, it was really elucidative. And as we discussed before through email, my point here, my final point here to ask you is that we have some institutions, public institutions like the Superintendência Financeira in Colombia, Banco Central in Brazil, the Central Bank of Brazil, which were very open to innovation and flexible regulations such as sandbox, experimental legislation and regulation, and ended up really good and developing and permitting that a lot of companies, initiatives, and democratization of the financial service happening in both countries. Otherwise, we have some, at least in Brazil, we are like currently living a recent crisis with the online bets, because there is studies that people are like are dropping the consume to spend money in bets because the bets entered the country without regulation. Now the financial ministry is trying to regulate and creating regulations to taxate this bets company, and also creating very strict compliance frameworks for these companies. And also, we talking about digital justice. Brazil was the pioneer of establishing AI in a Supreme Court. The Supreme Court of Brazil has an AI called Vitor, which is an AI that evaluates whether the appeals that are sent to the Supreme Court have the requirements to be tried by the Supreme Court. So it's a black box that makes this sort of trial of the appeals. Is it legal? But it's working and it's there. But does it comply with our data protection law? Does it comply with AI governance standards? I can't tell, but it's working there. So my question here is, wrapping up as discussed with Athenea as well, we have the Brazil, we have the United States building a lot of innovative companies. We have China building a lot of innovative companies. We have Europe building a lot of regulation. Which path should we follow, especially since we are now facing AI knocking in our doors? That will change a lot of professionals, a lot of sectors. So that's the idea. I'll start now with Erick. So just change the order. Erick, if you can like give your contribution on that.
Yeah, of course. The rapid advancement of in artificial intelligence is transforming industries across the globe, and Colombia is not an exception. From fintech and legal tech to digital health, AI has the potential to revolutionize how business operate, providing more efficient data-driven decision-making process. However, these advancements bring with them a host of ethical and regulatory challenges that must be addressed. For Colombia to fully embrace AI and its benefits, the country must strike a delicate balance between promoting innovation and ensuring that robust regulatory frameworks are in place to protect privacy, fairness, and transparency. One of the most pressing concerns with AI is data privacy. AI systems has often drawing a sensitive personal information to make predictions and decisions. And in Colombia, the law provides a strong legal foundation for protecting data, but as AI becomes more pervasive, this framework will need to evolve. For instance, AI systems often require access to real-time data, and the current regulatory framework may not fully address the implications of continuous data collection and processing. To ensure that AI systems are used responsibly, Colombia should consider adopting principles like data minimization, which limits the amount of personal data that AI systems can use, purpose limitation, which restricts their use of data for unintended purposes. Another critical concern is the fairness of AI-driven decisions. AI algorithms, while powerful, are not immune to biases. These biases can arise from the data used to train the algorithms, leading to discriminatory outcomes in areas like credit scoring, employment, and even healthcare. Uh, to address these issues, Colombia should implement guidelines that require AI systems to be audited for fairness. Uh, this could include conducting algorithmic audits to identify and mitigate problems, as well as requiring companies to provide a clear documentation on how the AI systems make decisions. Well, we have a big work here in Colombia, and we have in this moment like seven law projects in the Congress, and we don't have a real way to have the solution, is my opinion.
Okay, thank you, Eric. Athenea, I would like to hear from you, especially from the health sector. I don't, and don't worry, I like what I like about these events when we talk about technology. When we don't have to be afraid to do futurology sometimes and to risk our opinions.
No. Don't worry. I'm not that scared. Mm, Well, I would say that here in Colombia we have several drafts of laws that are currently being discussed in the Congress to regulate artificial intelligence. Yes. In the beginning, I was very into the debates and so on, but to be honest, I stopped doing that because my feeling is that we need to address that, considering the type of artificial intelligence that we want to regulate. Yeah. Personally, what I think is that we should try to adopt kind of a general framework of principles, um, and also to implement certain things that can be carried on by the authorities. I think the authorities could adopt a more supervision on the artificial intelligence systems and models. And I think also, for instance, specifically regarding privacy, we have to implement higher fines. In Colombia, the fines, when you breach the privacy data regulation, the fines are not that high. Yes, so I think that's something on which we could try to start working. Yes, but it's not really specifically related to artificial intelligence. So what I think is that maybe we should have a general framework of principles, and then while innovation starts to be applied, we can start amending specific laws. Like, for instance, if we identify that in consumer protection we need to enforce something additional, then we should amend that, or also in privacy or on liability matters. Yes, so that's would be my approach, because actually I think that a framework very robust like the one that they have in Europe may create difficulties in practice. Yes, because there is always this debate that states have. They want to have innovation, but on the other hand, they want to have a governance that fully protects the citizens, which I agree, of course, with. But I think you have to find this balance, and the balance is very difficult to find. We are seeing that in Europe now. They have the GDPR, they have the AI Act, they have the Services Act, they have the Markets Act, and so on. And what they have found now very challenging is that some of these acts, they are overlapping between them, which makes very difficult for companies to comply with all of them, and some of them are even repetitively. So I think the balance is very hard to find. Specifically about privacy, what I would say is that there is this wonderful principle of privacy by design, which we can use whenever we want to design this type of technologies. And also, along with methodologies like data design, we can create things that cover standards, but also that allow innovation to be implemented. Yes. So we already have principles. We have these principles in privacy. So we have to make them stronger and make things that are practical, but that obviously help to protect adequately the rights of the citizens. Yes. Finally, I would say something that I was thinking when I was listening to you and when Nicolás was speaking about ODR, and I was thinking in health, how, for instance, digital justice and health can be together, And I was thinking, here in Colombia, we have actually an action that is called Tutela, and it's an action that tries to protect fundamental rights from the citizens, and it can be filed by any citizens. And in the case of health, that's a fundamental right here in Colombia, so any citizens can file a Tutela action. When you think about the Tutelas action that we have here in Colombia, I think 27% of them are related to health. And most of them usually are related either to things where a patient does not receive proper treatment or does not receive timely the medicines. So I was thinking maybe an ODR for this type of things could be useful because it could relieve justice, and it could also provide timely access to justice to citizens. So I was thinking about that, and I think there could be a great connection in that in cases like the ones that we have in Colombia, because the rates for tutelas here are really surprising. We have, I think that the statistics for July of this year were like 460,000 tutelas. Yes, and 27% of them are related to health. And like 45% are related to petition rights, and probably some of these petition rights are even related to health. So I think here could be a great opportunity for technology to be implemented and to find also an additional connection between health, technology, and justice.
Yeah, I agree 100%. I don't know, because speaking about Brazil, we have the public sector providing health services in the private sector. I think it would work within the private sector, but I don't think it would be beneficial for the public sector to invest or adopt, at least at this time, a sort of ODR. I think there's some interests behind the morosity of the answers and the provision of the certain services. Yeah, but of course, I believe that's the future. And what you said, I agree with you 100%. Where if we talk about AI regulation, that we should do it by principle. We shouldn't have like a very strict and huge and complex legislation as Europe decided to do, especially because from my point of view, the regulation must be sectorial or by industry. If you are regulating technology, AI in the health sector, so the health authority will have to create its regulation, its principles. If you are regulating, what? Sorry? What?
Standards and things like that.
Yeah, the standards, of course. Yeah. If you're regulating the use of AI in medicine, in drugs, you should allow the Brazilian or the Colombian FDA to create its standards, and also with justice, in my opinion. When you're talking about the use of AI by courts, maybe even ODR, I believe that an authority such as in Brazil, the National Council of Justice or the Ministry of Justice should issue standards for the use of AI, because otherwise, if we create strict legislation, strict regulation, it will hinder development of this technology. On the other hand, we have to regulate it somehow, at least to understand and to challenge its decisions and its recommendations. So, Nick, I would like to hear from you, especially, I know there's a lot of points here to cover, but feel free to pick one or two of them. Just, I would like to hear you. You're muted.
I just wanted to say, Danny, that I fully and entirely agree with the three of you, because it's already 5. But if you want, I can expand on it, because I want to respect the time.
No, I mean, like, we still have 4 to 3 minutes. You can just
no. Well, it's cliche, but I fully agree. I think what both Erick and Athenea mentioned are key components of what's going on in Colombia, but I believe there's a lot more that's going to happen. I see Colombia, and I'm very optimistic by nature, but I see Colombia as a world pioneer in both legal tech and health tech, and potentially fintech. The thing is that there are many fintechs around the world, but I see also a nice trend. And Erick knows about it, that we've been talking about this for way too long. And well, Erick is an authority in Colombia about this, but as Athenea is in health tech. But then why I believe that Colombia can be a pioneer? Well, you might remember that when I started out with Redek in 2021, I traveled around the world looking for a potential market. And I went first to Indonesia, then to Spain, and then to Brazil, because I thought that perhaps outside of a developing country such as Colombia, and what I thought was kind of a small market, it was going to be easier. And I was very shocked when I went to Brazil, actually, when I spoke to you and to many of the people in the field, both in Rio de Janeiro and Sao Paulo. And even though Brazil is a huge market, I noticed, I sensed a lot of barriers for other companies, including a foreign Latin company, to get established there. So when I came to Colombia, I knew there was potential. And I decided deliberately that I was going to work here. And I think I'm not mistaken. Colombia has a lot of potential because people are really hungry for this kind of innovation. And I think we can really make a better future from here. But you'll hear from us.
I hope so. And since we are neighbors, I expect to drain a lot of this energy and innovation, because we need it here in Brazil. I think we need more than you. We need more than India when we are talking about digital.
Well, 80 million and
80 million lawsuits.
That's a lot.
80 million lawsuits. Yeah, that's so. Everybody, thank you so much for coming here and sharing your thoughts, your experience with me and with everybody that's watching us and that will watch us in the future. I hope to have you here again. We have a lot to cover. Of course, 1 hour is not enough. A lot of topics and interesting themes that we could discuss here today, covering health tech, fintech, legal tech. So that's it. Thank you again. And as I said, I hope to see you soon in the channel.
Thank you, Daniel. Bye.
Bye-bye.